Please be sure to subscribe and like our videos for updates.
Thank you very much, Mr. Speaker. Thank you very much, Mr. Speaker. Onofio Luke, by the amazing grace of God, I represent the people of Etinan, Nseribom, Surubium Federal Constituency. Mr. Speaker, I'm from Akwa Ibom State. Mr. Speaker and my dear colleagues, let me start by soliciting for your kind cooperation in supporting this bill for a second reading and subsequent passage. This bill seeks to provide for quick justice dispensation and completion of criminal matters part heard by a judge of either the Federal High Court, High Court of the Federal Capital Territory, or High Court of a state that's before his elevation to the Court of Appeal. It is a common practice where judges of the High Court get elevated to the Court of Appeal whenever there is a vacancy. When judges get elevated, criminal cases presided by them before they were elevated get stalled, and in fact start de novo, afresh. Owing to this unwholesome situation, Mr. Speaker and colleagues, these hallowed chambers, in conjunction with its sister legislative house, the Senate, passed into law the Administration of Criminal Justice Act 215 as a solution to that aspectual judicial problem. Specifically, Section 296 sub 7 legitimized the practice where a judge appointed to the Court of Appeal can effectually return to the High Court and continue to sit as a judge over criminal matters he partly adjudicated before his elevation. This legislative solution cum decision was an intelligent step towards discouraging waste of time and resources which often arises when criminal cases start anew. Last year, the Supreme Court, in its supreme wisdom, struck down Section 396 sub 7 of the Administration of Criminal Justice Act as being unconstitutional. The Honorable Court reasoned that a judicial officer cannot simultaneously assume the role of a judge of a Court of Appeal and still sit as a judge of the High Court, holding that such practice was not within permissible constitutional boundary. The court's view is principally anchored on the fact that Section 386, sub 7, is a statutory provision which cannot override constitutional provision. Mr. Speaker, distinguished colleagues, the decision of the court has thrown up myriads of problems and has sailed us back to a harbor of delay in criminal adjudication which we thought we had left. Mr. Speaker, distinguished colleagues, it is in this vein that this constitutional proposal is made to give dispensation to a judge of a High Court who has been elevated to the Court of Appeal to continue to sit as a judge in order to conclude part-heard criminal matter, given the advantages it gives to our judicial system. Since this is a constitutional alteration, the supreme fate which befell Section 396 sub 7 of the Act occasioned by the Supreme Court will not befall this constitutional provision when passed into law. And the objectives are: the bill seeks to amend the Principal Act to allow a judge elevated to the Court of Appeal to continue hearing criminal matter part heard by him before his elevation. 2, to assist in just and fair hearing and determination of corruption and monetary laundering matters. 3, to expedite justice dispensation and eliminate delay in justice delivery. And finally, 4, to save parties to criminal proceedings from unnecessary and avoidable costs and pains. Mr. Speaker, the bill seeks to amend Section 6 of the Constitution by inserting 2 new subsections, 7 and 9, which would enable a judge elevated to the Court of Appeal to return to a High Court to complete a matter the judge had heard before the judge's elevation. The right to the Honorable Speaker, the Honorable colleagues, I once again seek your support to consider this bill for expeditious passage into the law, as it would cause some revolution, positive revolution, in our criminal justice system. Mr. Speaker, I so submit, sir.
Anybody want to speak against? Against.
Of conflict of interest. How does a judge in good conscience preside over a matter which he had in the lower court and then sit on appeal on that same matter that he presided over at the lower court? There will be a fundamental conflict of interest here. He sat over a matter in the lower court as a high court judge, then he's elevated to court of appeal. He now sits as preside over the same matter at appeal. I think there is a fundamental problem here. It's not a matter of dispensation of justice, but then what manner of justice here? Even if that particular judge is not part of the appeal that will preside over that matter, he is still a judge in the court of appeal, and he may influence his colleagues to give him good judgment, to side with him so that he doesn't appear ridiculous in the previous judgment. So I think, honorable colleagues, this is a matter of fundamental conflict of interest, and I think I will appeal to my
Order,
my
please.
friend.
Gentlemen, order.
I will appeal to my good friend to step this matter, this bill down.
I represent the entire people of Mumbai, those in the federal constituency. Mr. Speaker, before coming here, I was a legal practitioner. Mr. Speaker, may I say categorically that there is no conflict of interest here and there can never be any. We have always been complaining as a practitioner in legal practice that our justice is often too delayed. And my Lord, when justice is delayed, it is equivalent to justice denied. Mr. Speaker, the moment a judge presides over a matter, a part-hard matter, in most cases, criminal matter takes 3, 4, 6 months, 1 year, 2 years. And you now ask that judge, maybe just remain one witness or just a judgment to be delivered because he moved to court of appeal. In most cases, when a judge, for example, is appointed in Bayelsa State, he will always be transferred to a different jurisdictions. And even if it's within his jurisdiction, all he needs to do is to excuse himself from the matter when he goes to appeal. There can never be any conflict. If we don't allow this bill to scale through, we will be killing exactly what we are trying to build. People are shouting outside that our justice is too delayed. We watch clips of how trials are conducted. We want to fast track our trials. There have been moves that we should establish courts for criminal cases only. We have not been able to do that. Now we are trying to go in between. Judges who have practically completed the trial, when they are in appeal, they can come back, 1, 2 sittings, deliver judgment, and go. There can never be any conflict. There has never been any conflict. The only reason why the Supreme Court shut down that provision was because it is an act which is in conflict with the Constitution. And what we are trying to do now is to move that same act to be in compliance with the Constitution of the Federal Republic of Nigeria. The court was not saying that it's going to be a conflict. They are saying this law is lower to the Constitution. And when there's a conflict, Constitution prevails. Now we are saying, let's move that law to the status of the constitutional provision. The Supreme Court judges are not saying there's a conflict. If we are creating an unexisting conflict here, we will only be killing exact thing what we are trying to build. Thank you, Mr. Speaker.
It is true that dispensation of justice is very important, and doing so on time is very important. But I will say that it would have been better to say, at least let's give the judge who have been elevated to the higher court a period of, say, 3 months to clear his table before he assumed the new office. If that is done, we have been able to clear the matter. But if you allow a situation where the judge who is presiding at the lower court will be the same person that will preside at the higher court, even if it is not specified that he is the one, Some judges will still insist they find a way of presiding still at that level. And that could be, and if you are in trouble, since it's a criminal matter, and the man is determined to lock you up, you will get locked up even at the upper level. So I think, in my opinion, let's have a 3-month situation where a judge that is appointed to go to the higher court, that 3-month period should be able to clear his table before he takes over from the new court, so that he does not come back and preside over matters he has actually done before. This is my contribution.
Bill, as proposed by my good brother, is to ensure quick dispensation of justice. Mr. Speaker, this bill as it is, it has a 2-pronged sword. Mr. Speaker, while ensuring quick dispensation of justice, will also impede on the career of the benchers. But Mr. Speaker, there's a way out. The way out is for us to use the instrumentality of this bill and overhaul the justice delivery system in the criminal justice sector. So, Mr. Speaker, I support the proposition of Honorable Luke Onefeld that this bill pass this reading so that at the committee level, we will add the necessary salt, cross the T's, dot the I's to ensure that Nigerians get justice. Bearing in mind the famous dictum of our famous jurist, Lord Denning, who said that, God forbid one innocent man goes to prison, but 100 criminals can be set free. So, Mr. Speaker, for us to achieve that, let this be past second reading at the committee stage, led by you. We'll dot the I's and cross the T's. Thank you, Mr. Speaker.
How can a judge, for instance, sit in 2 different court justices at the same time? Without time limit? There will be certainly conflict of interest, and the judge can decide to sit on these cases to eternity. So, if as much as we are trying to cure the mischief in that aspect, I think we should cure it properly. That's my own belief. For a judge to sit in 2 different courts, superior court of justice, I think it is that we should look into it properly. Yes, sir.
I remain Uzoma Nkem Abonta. Mr. Speaker, I have listened attentively the passion, intention of the author of the bill. Mr. Speaker, people write a bill to remedy existing wrong or to cure a certain defect. Mr. Speaker, part of the problem we have is slow dispensation of justice, particularly criminal justice. Part of the reason why people don't even go to court is that a criminal matter may linger in court for 7 years and above. In some cases, people are awaiting trial, leads to prison congestion. So his mind was actually to decongest or bring a fast dispensation of criminal justice. A case in mind is the case of Senator Auditor Carlo and EFCC. This is the purport. I think this captures that scenario in that matter. The ratio decisis in that matter, where he went upstairs and came downstairs to still speak. The worry of those who are attacking this bill is, can you speak from up and down? But I think that anything we can do to get fast dispensation of criminal justice will achieve a lot for Nigeria. I want to propose a middle course. For example, I also understand their worry. A cure that will be in the immediate could lead an alternative. Most judges, they are human beings, they have interest. Should he come back downstairs with that interest? Is it criminal justice? Like Honorable Nanda said, if I'm appointed now, for example, I'm in this house, and there's a vacancy in my state and I do governorship. The moment I take, see, I'm only wishing myself to. While I'm here is take some 3 months, seek all the allowance, do all the clearing I need to do, and sort myself out before I go to take the oath. pick all the debt, pick all the allowances, pick all that he left, and then when I take the oath, I may not come. I therefore think that we can't leave that not attended. We must discuss it widely. We must find a cause, because it will happen. A High Court judge promoted. If you're having a lot of matters, you can say, apply. I will take my oath after 3 months when I must have cleared my table. Because, or the system will check. You have so much matter to do. Within 3 months, tidy up. It's for him to now look at those he had advanced. Because for you to also talk on a matter, you must have gotten to the point of judgment. So it will be difficult to start de novo. And then you can say, I'm going to take 3 months to write it. But if you're a High Court judge, you use what they call assignment order to come back to conclude. My brother, the problem I worry is that will he wear 2 caps? Court of Appeal, High Court. The law is a very, very, I wouldn't say meticulous, but they look at it a kind of secrecy and like a spirit. The law will now say, did you give that judgment as a court of appeal judge, or did you give it as a High Court judge? The oaths are different. You assign, for example, in these chambers, for a senator to sit in here, you suspend their rules. Am I right? You create a special waiver. So he's asking for a special waiver to do that. And we're saying, we can't, what he raises is a very serious matter, we can't throw it away. But what is the middle course? Saying, before you translate, tidy your desk. Give you 3 months. So that they will know you will begin to do something. Because it's a big problem in Nigeria today, a middle course. So I agree with those who said, let us have the second reading done so that we'll have a wider discussion on it. When you are more relaxed, it will still come to a table. When you are more relaxed, in a comfortable place, not in a chambers, in a hotel environment, when we're all relaxed, we'll now think well and give it a better interpretation and look.
Abianti.
Distinguished colleagues, my name is Solomon Bob. I'm from Rivers State. The bill we are considering now is an interesting one. And for those of us who are lawyers, who understand what the courtroom practice is and what this bill, the mischief this bill seeks to cure, we're not in any doubt, I am not in any doubt as to the usefulness of this bill. I think it's something that has long cried out for attention. So I'm glad that my brother brought it up today. I note with interest the concern the speaker is raising. Okay, but that is a very infinitesimal concern, I mean, compared to the overall objective of this bill. The philosophy of this bill is to accelerate justice dispensation. And that is what we need the most in our judicial system. That is where I'm leaning towards in agreeing with this bill. We should give it a passage on this floor. It gets to the committee, which, by the grace of this House, you head in these chambers at the Constitutional Review Committee. You can there look into more scrutiny, look with more scrutiny, some aspect of it that you have concerns about. But this bill has to pass through this floor. It's an important bill. I'm saying this, Mr. Speaker, as somebody who is experienced in courtroom practice. I won't say more than that. Thank you.
Down.
People like us who are not learned, we are only getting more confused. Even though I realize that what they were saying, if I'm correct, that if a particular judge is handling a case and he has been promoted to Court of Appeal, the case will have to start afresh. I would like to advise, if you will form a committee of the legal minds, which is normally happen in this chamber, to look at this and advise the House as appropriate. All the two people, they seem to convince us, so we are really getting confused. Thank you. So, but if you form a small committee of the legal mind, will be advised as appropriate. I shall submit. Thank you.
Bagos.
Mr. Speaker, honorable colleagues, I won't be speaking as a lawyer or someone that has been in the court. I'll be speaking on this as an anti-corruption expert. And again, perception of Nigerians, especially from what the bill seeks to do, to quicken dispensation of justice and completion of criminal matters. Just that title, if from here we look at trying to say we do not allow it to move to the second reading, perception is number one and key issue. First of all, perception that will come on us that we are not willing to quicken dispensation of justice. Secondly, Mr. Speaker, on the issue of what has been happening with cases in various courts that have to do with corruption, because all the loopholes that either the legal experts and so looking at what is there for them to use as a result to be able to delay any criminal justice. To me, I believe that if we take this to the committee level, let the experts discuss this, look at the technical areas, that will be better for us. But perception is very key at whatsoever level we're trying to look at this bill. But to me, let's allow this bill to go in for the second reading, look at the technical aspect at the committee level, and again, it's a constitutional matter. The constitutional committee led by you, sir, will be able to handle this.
I think it would be more right to say you are looking at this bill from the
from Sokoto State. Thank you very much, Mr. Speaker, for the opportunity. Honorable Luke is a very close friend of mine, but I think at this juncture I will have to draw his attention, particularly on the very body of this bill. I will read through, you read with me. A bill for act to alter the Constitution of the Federal Republic of Nigeria 1999 to provide for the quick dispensation of justice and completion of criminal matters being tried by a judge of a high court before his elevation to the Court of Appeal. To me, I think these are two different things. For example, a judge may not know if he is due for elevation. And even though he knows that he is due for an elevation to the Court of Appeal or any other court, Mr. Speaker, that will only maybe force him to do something sinister that may not be in the best interest of the person he is trying. Remember, High Court is being manned by one judge. So now if you allow him, at the end of the day, there could be an undue interest. So for me, this bill is unnecessary because it tends to contradict the very principle of check and balances as enshrined in the Constitution, and as well as infringe the fundamental human rights of the very person being tried. Lest we forget, if we are talking about criminal justice, we are talking about something that involves somebody that needs to be investigated thoroughly and truth established. This is my humble submission. With due respect to my friend, Honorable Luke. Thank you so very much, Mr. Speaker.
With my colleagues who have vehemently supported this bill. Mr. Speaker, those of us who are actors in the courtroom know very well that this bill is germane at this time. On the part of the litigants and their lawyers, this bill seeks to carry out heavy load out of the litigants. Mr. Speaker, we are aware that there are situations where matters are just adjourned for an address after several years, only for the judge to be appointed to higher court of appeal. And that means the case had to start de novo. And starting de novo means you have to start all over. Meanwhile, the criminal whose case is being tried has stayed in detention are waiting trial for 5 to 6, 7 years, and starting to know means you have to stay an additional 4 to 6 years in detention, in the prison custody.
Honorable Kumo, you have to take, sorry, please, permission from you.
One, on the ground that those who are raising the issue of conflict of interest, I'm sure that at the committee level of public hearing, the issue of the timing could be decided at that level. Even those who said 3 months, you can't even decide whether 3 months will be enough for such matter to be closed out by the sitting judge. Rather, maybe at the public level, public hearing, stages of cases could be enumerated to say if a matter has been addressed for hearing or address has been delivered, then at that stage, the judge can still sit behind and pass the final judgment before going to the appeal court level. Because if you don't do that, we'll find a situation where criminals languish, some of them even die in detention for over 15 years in a matter that would have been disposed of in 4 or 5 years' time. Mr. Speaker, I support this bill. Thank you.
Thank you.
Experience a lot of issues with my lawyers paying a lot of money at the end. This simple transfer or elevation of the judge to the next level. Mr. Speaker, we are lawmakers here, and lawmaking is a process. So I see no ambiguity in this. We just allow it to go for the second reading to go to the committee. Experts will be called to discuss this issue for and against. So what is the problem with that? So we are trying to eat our cake and, trying to be the judges on our own courts. So I think we allow it to go so that Nigerians can dictate what they want as far as this process is concerned. But I think there is injustice for some of those who are seeking for justice when it comes to the judgment at the lower court. Then suddenly the judge is elevated. And you are not even sure who will go and influence the elevation of that judge. So we don't know. Once he knows he's going to fail in the judgment. So we need, this bill is very important to even forestall a lot of corruption within the system. So I support let it go to the committee so that Nigerians can decide what we want. Thank you.
Act to alter the Constitution of the Federal Republic of Nigeria 1999 to provide for quick dispensation of justice and completion of criminal matters being tried by a judge of a high court before his elevation to the Court of Appeal and for related matters. Second reading.